invest arbitration. Just to put it in context, for example, for Russia, Kenya has significant imports that it gets from Russia, particularly in fertilizer and cereals. And I think the figure is around 400 million USD per year. Now, all those contracts are obviously subject to particular vulnerabilities from sanctions. You must all be aware of the potential of the tariffs that have been placed on Kenya by the US, which obviously may have significant effects, and in other similar jurisdictions in Africa. And to sum it all off, to show why sanctions and tariffs are relevant, in 2024, the ICC published information that in the first quarter of 2024, 25% of all registered cases had to do with sanctions. So definitely a very relevant topic, and ESG, something that we all know is becoming very prevalent in terms of the exposure in the African continent, and more relevant in terms of its applicability in the contracts that parties are entering into. So to decipher these topics, I have a very eminent panel of experts on this subject. Perhaps I'll start at home with Ms. Pauline Mcharo. Ms. Pauline Mcharo, to a lot of you, will not need an introduction, but I shall. She's the Deputy Solicitor General in the Office of the Attorney General and Department of Justice. She heads the Legal Advisory and Research Division. She served as Deputy Chief Negotiator of the Kenya-US Free Trade Agreement and Kenya-US Strategic Trade and Investment Agreement. She represents the Attorney General in various WTO national committees and other multi-stakeholder forums. She has represented the government in complex international investment and commercial arbitration before the auspices of ICSID, ICC, and LCIA, and assisted in resolution of territorial and maritime delimitation disputes and advising on international law matters, and is a WTO Disputes Governmental Panel member. She holds a Master's in International Law from the Graduate Institute, Geneva, LLM in International Trade and Investment Law in Africa from the University of Pretoria, jointly with the University of Amsterdam, and an LLB Bachelor of Laws from the University of Nairobi. Welcome, Pauline, and thank you for taking the time. Our second panelist is Sudhanshu Roy. Sudhanshu is a partner with the International Litigation and Arbitration Practice, Washington, D.C. of Foley, Hoag. His practice focuses on representation of private companies in international commercial arbitration and cross-border litigation before tribunals administered under the AAA, ICDR, ICC, SIAC, ICSID, UNICITRAL, PCA, and SCC arbitration rules, as well as investor-state arbitrations, especially in cases involving representation of foreign states, state-owned entities in high-stake global disputes. Sudhanshu is a fellow of the Chartered Institute of Arbitrators and the Malaysian Institute of Arbitrators. He is empaneled as an arbitrator with several arbitral institutions in the United States, India, UAE, Malaysia, and Brunei Darussalam. He is also a member of the steering committee of the CPR Institute's Young Leaders in Alternative Dispute Resolution 2025 to 2028. Welcome, Sudhanshu. Thank you for joining us all the way from Washington, D.C. And last but not least, Mrinal. Hi, Mrinal. Mrinal is the Managing Director in Secretariat International and recognized as one of the leading expert witnesses in international arbitration, Who's Legal, Arbitration 2019 to 2025 lists, and Thought Leaders Arbitration Expert Witnesses 2021 to 2025. Mrinal has provided expert evidence on complex financial, economic valuation, and damages issues in over 40 matters before the auspices of SIAC, ICC, LCIA, HKIAC, DIAC, UNCITRAL, ICSID, PCA cases, and assisted clients in over 65 disputes cases representing corporates across Americas, Europe, Africa, Asia, and Australia. He has also advised international clients on more than 100 valuation projects, and he has commenced his professional career with Ernst & Young in New York in 2007 and brings with him about 18 years of relevant experience. Welcome, Mrinal.
Thank you, Nikhil.
So to perhaps jump into the topics straight away, and perhaps we can start with the topical issue of sanctions and tariffs. And Sudhanshu, I'll start with you. How do you see trade sanctions and tariffs affecting commercial relationships between African entities?
Thank you, Nikhil, and thank you to CIArb and the organizers for having me on this panel. Very, very happy to be here. I was in Nairobi, I think last month, and I think I'm allowed to say that we had initially planned to do this in person, which would have been awesome, to actually be there and meet all of you. But I think the online medium is also something that we've gotten used to in the last 5, 6 years, especially after COVID. It's early morning here, but I'm very happy and delighted again to be here. And thank you also to my fellow panelists and good friends. Uh, so I think, yeah, I think your question was, how do you see trade sanctions and tariffs affecting commercial relationships between African entities? I think, we've had uh, the discussions around tariffs and sanctions have become quite intense and political, I think, over the last 18 months or so. This is relatively, in my understanding, at least as far as the United States is concerned, where I am based, an issue that was not that much frequently discussed, prior to the current US administration. But I think it has become, these discussions have become very political, especially here in the United States. Uh, and I've participated in numerous conferences and events where I've been asked the same question. Uh, One thing I will say is that on the question of, for example, tariffs, right? I mean, you would have seen that these tariffs were imposed based on these emergency powers provisions that are available to to the executive government here in the United States. And those powers were recently invalidated by a judgment of the Supreme Court, ruling that the president does not have the authority under the IEPA law, which is the Emergency Powers Law, to impose tariffs on any country. That power actually rests and vests with the US Congress, because that's how the Constitution has been written. So I think, although, I mean, my point here is to say that although these discussions are very intense and political, but the actual impact of the tariffs on the market may not be as rooted, as deep rooted as these discussions would seem to suggest, right? Because these tariffs have, as I said, were only imposed at some point, I think, in the beginning of last year, and then they were suspended for a while. Then there was these challenges, and now the Supreme Court has invalidated it. And now I think the administration, based on the current media reports, is in the process of refunding these tariffs to the companies, to the US importers which paid those tariffs. So I think the actual impact, I'm not of these tariffs on trade relationships, I'm not sure. And in fact, I have data here, I have some numbers by the Brookings Institution, for example, which says that between 2025 and the middle of 2025 and the beginning of 2026, trade from African countries actually has increased to the United States. So, I mean, all of this is to say that if you look at the actual numbers, the impact may not be that much in terms of trade. But that is, I'm not trying to discount the commercial impact of the tariffs, and I have no doubt that the tariffs have impacted the commercial relationships between African parties, and has had an impact on how contracts are being negotiated and implemented in actual practice. I'll also add that it's not just the tariffs, it's a host of other measures. I think you mentioned sanctions, but it's not also just sanctions, it's a host of other measures that have been taken by the current administration, which may disrupt commercial relationships between parties. I'm not sure the extent to which it will impact trade. I think the one example is the African Growth and Opportunity Act, which is a law passed by the US Congress and has been in place for 20 years, which, as you know, provides certain sub-Saharan African countries with duty-free access to the US market for over 1,800 products. And under this program, the eligible countries receiving the benefit were required to establish and make continual progress towards establishing a market-based economy, the rule of law, political pluralism, right of due process, and so on. But this program actually lapsed in September of last year. And there's no indication that it will be revived under the current administration. So I think it is measures such as these which may have more of an impact than the US tariffs. The second development that comes to mind is the elimination of the USAID, United States Agency for International Development, which I don't need to tell the audience has had a massive presence in the African continent and also large parts of Asia over many decades. It has, I think, funded not just public health programs, but also many commercial and startup programs. I know in Kenya, for example, the USAID was a big supporter of some of the agricultural startup economy. But with the gutting of the agency, with the complete elimination of this agency, I think that this is going to have both of a obvious humanitarian impact, but also a commercial impact. So I think it's not just, I mean, all of this is to say it's not just the tariffs, but a host of these other developments which may have more of a pronounced impact because the tariffs were in place for a limited period. I know the administration has reimposed tariffs. I think they will again lapse after a period of 150 days because the law under which they've been imposed only allows the president to have it in place for 150 days and not beyond. And I'm confident that there's not enough votes in the US Congress to have the tariffs in place for a prolonged period, especially with the looming elections coming up here in the United States in November. I think I'll stop there. I can talk about a little more about the precise impact on commercial relationships, force majeure clauses, supply chain disruptions, and so on. But I think we're going to have I don't want to take the floor entirely, and I'm sure my co-panelists have more interesting thoughts.
Thank you for Sudhanshu for that very important background information. So Pauline, maybe on a more practical basis, what sort of disputes do you see are likely to arise as a result of sanctions being placed on various countries, state entities, individuals, based on your experience and just foresight?
Okay, first, thank you so much for the opportunity. Good afternoon, everybody. Well, and thanks, Roy, for giving a background on how trade sanctions and tariffs would affect commercial relationships between African entities. First, I'd like to state that while some African countries and individuals are facing sanctions, there have not yet been any disputes on the same, arbitrations on the same. There are some countries that are on the sanctions lists, but we haven't had any disputes in Africa on the same. But as we've seen, particularly, there is need to look outside Africa to see what kind of disputes are coming up in this area. And Roy will back me up. Particularly Russia, in the Europe and Russia, and there's some disputes that have come up relating to sanctions. Europe, Canada, Russia. What we are seeing is that individuals are now filing suits, and are filing suits in courts and in arbitral institutions as a result of sanctions being imposed by states. Like we have, I've seen a case in Canada where there is Igor Makarov versus Canada, where an arbitration was filed under Canadian Moldova Foreign Investment Promotion and Protection Act after Canada sanctioned a former Russian citizen. And this individual, Mcharo, claims Canadian dollars 350 million and alleges violations of investment treaty protections. So we are moving to, there's also another case in Luxembourg, a PCA case, Michael Friedman, but I think it's a PCA case. And they say it's the first known ISDS case where EU sanctions froze Friedman's assets, including his holding company, in compliance with EU-Russia measures. He's claiming USD 16 billion. And ISDS is being utilized to challenge decisions that are fundamentally state or national security level, testing limits of what is appearing before arbitration disputes, where previously cases were mainly commercial and investment, and now they are sanction-related disputes. You can also see when it comes to commercial entities, disputes that may emerge would include disputes that would involve price adjustment and renegotiation disputes where tariffs are involved, where a party would invoke hardship or material adverse change clauses, non-performance and penalty disputes where a party would claim inability to perform due to sanctions compliance obligations, and seeking unfreezing of finances that have been frozen by banks. Okay, and then we also have a case, a historical case in Africa that involved the state immunity and sovereign entity disputes, that Trentex Trading Corporation versus the Central Bank of Nigeria. That's a historical case where we saw where Nigeria's central bank issued a letter of credit for cement ordered by the Ministry of Defense. After a military coup, the new government ordered non-payment. And the UK Court of Appeal held that the bank was not entitled to state immunity because it was a separate legal entity conducting commercial transactions. So critical for African parties, it's some state-backed entities may not be able to claim sovereign immunity to avoid payment obligations. That's what the case illustrated. So we may seek individual claims which are novel, as we've seen that's happened in Europe and in Canada, involving Russia and sanctions, and we would see more of commercial litigation. That's what's coming to me. Thank you.
Thank you, Pauline, for those review of those very important cases. I mean, I myself have not been involved in a dispute where the subject matter of the dispute is a sanction. But as you correctly note, I think a lot of the disputes that we're seeing are really lie around difficulties in following through with contractual obligations, both payments and perhaps delivery of the subject matter of the contract within a time frame or at all because of the imposition of particular sanctions. And a relevant case which has been to a number of courts, the Russian court, the English court, arbitration, was well, I'm not sure it was arbitration, but definitely the English court and the Russian court was the RTI and no shipping case. So just with that introduction, if Sudhanshu, a party is faced with a situation where they're unable to fulfill particular contractual obligations due to sanctions, I'm leaving tariffs aside for a while because it is untested, and as you correctly noted, the impact is yet to be seen. How would a party be able to frame a claim that has affected their contractual relationship based on a sanction?
No, that's a very interesting question. And sanctions, I think, as you rightly pointed out, have been litigated and so the subject of dispute for quite a while, because the sanctions, we were in this free trade and the liberal market economy era for a long time, where I think global trade was at least allowed to flow between nations on a reciprocal basis for a long time, and tariffs did not disrupt the global economy until very recently. But I think sanctions are a little tricky because sanctions have been always in place, and there are at least as perceived by the West, there are these certain unfriendly countries which have been the subject of these sanctions for a very long time. I think the question is a little tricky. I mean, your question, as I understand, is it how does a party frame such a dispute? How does a claim such as this even arise? And I think you mentioned one case, and I think Pauline may have also mentioned briefly the MUR shipping versus the RTI case, which I think is a good example, and it might be worth looking into the facts of this case to give you an example in a practical context as to how such a dispute may arise. Now, this MUR shipping versus RTI case is a recent case. I think the dispute, the contract was entered into before this current era of tariffs and sanctions, which have been intensely debated and discussed. It's about 10 years old. And the contract provided that MUR, which was the claimant in the arbitration, would carry consignments of bauxite from Guinea, which is on the West African coast, from Guinea to Ukraine. So a dispute which is connected to Africa. And it was an express term of that agreement that payments would only be made in US dollars. And the agreement also contained a force majeure clause, which said that force majeure could be invoked for an event or state of affairs court by reasonable endeavors, unquote, made by the party affected. So in other words, a party could invoke the force majeure clause if it can establish that it cannot overcome the force majeure event by virtue of its reasonable endeavors. Now, in April 2018, RTI was targeted by US sanctions because it was linked to certain, I think, Russian entities. And MUR, which was the shipper under this contract, invoked the force majeure clause and said that it will not perform its obligations because US sanctions prevent it from accepting payment in USD from RTI, which is a sanctioned entity. RTI offered to make payments in euros, but MUR refused and suspended the contract. RTI initiated arbitration under the London maritime rules, arguing that the force majeure clause could not have been reasonably invoked because MUR could have accepted payment in euros, which is a freely convertible currency internationally accepted, and so on and so forth. Now, the arbitration tribunal found in favor of RTI because it said that MUR had a reasonable obligation under the contract to accept, payment in euros and to do everything to keep the contract alive. The case went through a series of proceedings in the UK courts, which culminated in a decision issued by the UK Supreme Court in 2024, which ruled that a reasonable endeavors provision contained in a force majeure clause does not require a party to accept non-contractual performance in the absence of clear wording to that effect, in the sense that a party is not required, or in other words, a party is not required to go beyond the express words of the contract and do something which it is not required to do. So in this case, MUR was not required to accept payment in euros under the contract, and therefore it does not have an obligation to do so absent express wording in the contract. Now, the implication of the decision and the obvious takeaway is that in order to mitigate the impact of sanctions, you must have express wording in the contract such that it requires parties to demonstrate reasonable behavior in order to mitigate and avoid the impact of those sanctions. So in this context, for example, accepting payment in a different currency is a good example of how a reasonable party could mitigate the impact of a force majeure event. So I think it all depends. I mean, to answer your question in very short, terms, Nikhil, I think it all depends on the express words of the contract, at least in the common law context, in jurisdictions such as Kenya or the UK or the United States, where tribunals and courts are likely to examine the words of the contract, how the contract is written. And in this case, this is a good example of the UK Supreme Court basically saying that the contract does not require a party to accept non-contractual performance. But if it had, then maybe we would have seen a different outcome. So I think especially I would say the takeaway is also when you're dealing in jurisdictions which are the possible which may be possibly impacted by sanctions. So in this case, they were dealing with RTI, which is a Russian linked entity. So if you're trading with a Russian linked entity, if you have a contract, then I think you would be well advised to consult with your lawyers and with your advisors to have express language in the contract to avoid the impact of sanctions. And I think that's one possible way to mitigate, but I'm sure there are others, and Pauline may have more to add.
Thanks, Sudhanshu. So yes, I mean, from what we've seen, force majeure is the clause that parties rely on most of the time, and really it's about the wording of the force majeure clause as to what amounts to a party being unable to fulfill their obligations. Pauline, any views on that, on force majeure as a head of claim arising from a sanction?
So from what we have seen, and I agree with Roy, that from the cases we've been looking at, including the MER shipping and RTI and other cases, is that the current the threshold for force majeure is very high. And for the tribunal, most of them are moving towards strict interpretation. Therefore, parties should endeavor to draft force majeure clauses narrowly, listing not only war, disaster, but with these emerging issues, also listing sanctions or tariff changes like the unilateral tariffs Trump has brought up. You can see, like in a case, some cases we're looking at, like where a Brazilian case where a Chinese company called Trina Solar materially breached its contract with in a Brazilian project by failing to deliver solar panels on time. The tribunal rejected the Chinese company's defense that Chinese government restrictions constitute force majeure. It found that, and it found that the Chinese company is liable. The Chinese company could not use supply chain volatility, and you can see with this emerging with this emerging geopolitical event, supply chain volatility is there and regulatory changes are there, but the tribunal ruled that these events are foreseeable. They were not seen as unforeseeable events, but the supply chain volatility was seen as foreseeable risks that excluded the company from relying on force majeure. Similarly, in another arbitration, Miller Brothers and Recon Corporation, the tribunal considered also excluded the company Miller Brothers from relying on Recon from relying on force majeure, and also this related to global supply chains challenges with solar panels, which include the manufacturing and shipping difficulties, and these events. The tribunal said that the circumstances were not unforeseeable but foreseeable. In a most recent U.S. sanctions case, PGP versus Pipe Survey case that relates to the recent U.S. secondary sanctions on Iran, you'd think that the EU would, this is a sanctions issue, you'd think that the EU courts would be lenient on accepting force majeure in a US sanctions related case. But in this PGP pipe survey case in a Rotterdam District Court, the court rejected the force majeure defense based on US sanctions. Interestingly, the EU has a statute that blocks its companies from using defense, from complying with extraterritorial sanctions. So the EU courts said where EU companies are, you're doomed either way, or it's either way you're doomed if you comply with the US sanction, you are violating the US blocking statute. So companies are prohibited from complying with extraterritorial US sanctions in this EU blocking statute. So the contractor was bound by the contract to inspect pipes in Iran. And this case involved pipeline inspection company for an Iranian company. So the company pipe survey was asked to comply with its obligations. Also in line, another case at the Hague, at the EU, within the EU, a Dutch software company was told to continue performing its contractual obligations despite the risk of violating US sanctions. This company called Exact had concluded an agreement with a company where the company would distribute software supplied to companies in Cuba. So Exact ceased its performance due to US sanctions, but the company and the software company argued that it's legally obligated to terminate the agreement. However, the court found that it has to comply with its obligations. So you can see that the interpretation and the application of force majeure in sanctions by some courts and tribunals within other jurisdictions has been very narrow. Thank you.
Thanks, Pauline, for that very important review. I think two issues are raised there. One is obviously the wording of a force majeure clause. The courts will interpret the wording as it is in the contract. Terms such as using reasonable endeavors to fulfill contracts will be judged with that leniency as well. So obviously advisable to have force majeure clauses that expressly refer to sanctions. Alternatively, something that's popping up more in contracts are actual sanction clauses. So if there is an issue with performance of a contract, a sanction clause can be relied on to raise a claim against the other party, or to halt fulfillment of certain obligations due to the sanctions. Another matter out of probably English common law is that if your contract does not have a force majeure clause, then there is the possibility of relying on the common law principle of frustration, but that's obviously a discussion, a wider discussion. And another important point, Pauline, you raised, which will take me to the next question, is the jurisdiction that's involved is very important, because a number of jurisdictions have their own legislations and how they deal with sanctions, which will in turn affect arbitral proceedings, enforcement, and the rest. I think in the RTI and MUR case, while arbitral proceedings are ongoing in the UK, which I believe was the seat of the arbitration, RTI went to the Russian courts, which has legislation in place that says any disputes that relate to sanctions concerning Russia or Russian entities, the Russian courts have sole jurisdiction or exclusive jurisdiction. Now, because the arbitration was taking place in London, the UK courts issued an anti-suit injunction and said the dispute was properly before the arbitral tribunal, and the London courts do have, the English courts do have jurisdiction. So just moving on to how sanctions may affect the actual arbitral process. And perhaps, Sudhanshu, I'll ask you the question, what procedural mechanisms should arbitral institutions and tribunals have in place to mitigate sanctions and the risks that arise from them? So perhaps, firstly, what are the risks that arise that may affect arbitral proceedings at the start of an arbitration, and how can those be addressed by arbitral institutions?
Sure. Thank you, Nikhil. I think the risks are obvious. I mean, and I think Pauline addressed some of them, and you've also covered some of them. I think the primary risk that I see, one of the most basic threshold questions that arises in these sanctions related disputes, at least a dispute which directly relates to the sanction or directly relates to a party which is under sanctions, is whether such a dispute is even arbitrable. And I think there are some decisions which clarify that a dispute being the subject of sanctions or the party being the subject of a sanction does not per se or by itself limit the ability of the tribunal to hear that dispute. I think Pauline referred to some of those cases. I think Fincatinieri versus Ministry of Defense of Iraq, which is an ICC tribunal. I think the National Air France versus Libyan Arab Airlines, which is a Canadian domestic arbitration, which also rejected the argument that UN sanctions against Libya rendered the dispute inarbitrable. So I think sanctions per se does not make a dispute or does not impede the authority of the tribunal to hear it. But I think the practical consequences of having or hearing such a dispute are enormous, because it would result in, for example, discussions about enforceability of an award, right? If a party prevails against a sanctioned entity and the sanctioned entity is required to make certain payments, or even if it loses, and it is required to pay payment to the sanctioned entity, how is it even going to circumvent that prohibition? I think that's a primary risk. The other risk is obviously by entering into a legal or a commercial relationship with a sanctioned entity, are you yourself circumventing the sanctions regime and could risk potential liability by being the subject of secondary or tertiary sanctions? So I think the risks are, regulatory, political, and legal in nature and multifaceted. How are institutions dealing with these risks? I think not all of the institutions address the issue of sanctions directly. I'm aware that some do, and I think the LCIA, the London Court of Commercial Arbitration, is a good example. In fact, it is the only major arbitral institution that expressly addresses sanctions in its rules. And I would refer you to Article 24A of the 2020 LCIA rules, which provides that the LCIA court may refuse to appoint an arbitrator and may suspend or terminate proceedings where the LCIA determines that it would be contrary to the applicable law, including sanctions law, meaning thereby that if an arbitrator is the subject of a sanction, or if a party is the subject of a sanction, the LCIA court is within its rights to decline administration of the case if sanctions compliance under the applicable law is compromised. The ICC rules, which is by far the most widely used rules in the world, does not have an express sanctions provision, even if it's 2021 rules. I think the rules are about to be revised. They've started the consultation process. So it remains to be seen whether the new rules address sanctions, but the 2021 rules do not. But I'm aware that the ICC has several practice notes and compliance protocols which require the ICC Secretariat to conduct sanctions screening prior to taking the authority to administer a case. It also requires the ICC Secretariat to conduct sanction screening of arbitrators, and the ICC tribunals, obviously under the general competence under Article 23 and 24 of the ICC rules, have the power to take measures to preserve the efficiency and integrity of the proceedings, which would include a power to enforce sanctions compliance. Other rules such as SEAC, HKIAC do not have sanctions provisions. I know that SEAC has some sort of internal mechanism to address sanctions. I'm not sure the extent to which the Hong Kong rules do. or the Stockholm Chamber of Commerce rules do. ICSID, which is predominantly used in the investment arbitration context, also revised its rules in 2022 and does not include any new obligations on sanctions. And that creates, I mean, in the ICSID context, one of the parties or the respondent is always a state or a state-owned entity. So I think the considerations are different because you're not dealing with private parties, you're dealing with states. And I'm not sure if some of these sanctioned states are even members of the ICSID convention. So in which case, the claims cannot be brought against them in the ICSID forum. I think, in terms of the procedural mechanisms and what can be done for the future, I think there is obviously sanction screening and compliance protocols that most arbitral institutions can establish. As I said, some of them are already doing it, but I think it needs to be more institutionalized and more made robust so that you check for sanctions not just against the parties, but also require, for example, disclosure of beneficial owners, any interested parties or affiliates that may be the subject of sanctions. You should also check for sometimes legal representatives may be the subject of sanctions, especially, for example, in disputes involving Russian entities. And therefore, institutions should conduct these primary and secondary sanctions check. And besides practical implementation, rules should address them. LCI obviously does. And as I said, the ICC is in the process of revising its rules, and given its predominance and eminence as the most popular arbitral institutions, if the new rules address the sanctions, it may spur other arbitral institutions to do so as well in the future. The other thing that can be done is that many sanctions regime, including the US sanctions regime, permit the issuance of licenses authorizing specific transactions that would otherwise be prohibited. And I think institutions should be aware that in many cases, a general or a specific license can be obtained from the relevant sanctions authority to permit the administration of arbitration proceedings. So I know when Russia invaded Ukraine in 2022 and sanctions were imposed, a lot of the arbitrators and lawyers here in the United States applied to OFAC, which is the Office of Financial Sanctions implementation here in the US, for an express waiver or a license in order to continue participation in those proceedings. So similarly, institutions could also address this by expressly allowing the rules to permit obtaining of a license or a waiver. In fact, a few years ago, we also advised Iranian-linked entity in obtaining an OFAC license in order to obtain the payment of an award. So I think institutions should be aware of these mechanisms, and since an arbitration does not involve any sort of commercial dealings or long-term commercial relationships with sanctioned entities, it just involves the administration of disputes. Obtaining a license or a waiver is a good way to circumvent or mitigate the impact of sanctions. I think the final point is in terms of payments. While sanctions can block payments between the parties or to the tribunal, there is the possibility of alternative payment mechanisms, including through non-sanctioned intermediaries, use of escrow accounts, where you do not make payments directly but put it into an escrow, and then the payment is released once the conditions are fulfilled. We could also, the MUR shipping case is a good example of payment being made in currencies which are not subject to sanctions. So you could negotiate express contractual provisions that allow you to undertake reasonable non-contractual efforts to accept payments in different or alternative currencies. And I think those are some of the examples of practical ways in which this can be mitigated by arbitral institutions.
Thanks, Sudhanshu. That was quite comprehensive. And as you correctly note, the real issue for arbitral institutions is, how do they process payments coming in from sanctioned entities or individuals or states. And one way is obviously the actual rules give a procedure that the institution needs to follow, and the LCIA is a good example. And you know, subject to parties providing full disclosure as required of ultimate beneficial owners and the rest, arbitral institutions will likely still administer the arbitrations if they're able to get, as Sudhanshu said, general licenses. I know for the LCIA in 2023 or 2022, they did obtain a general license from the Sanctions Office, the OFSI, in London for the Russia-Belarus arbitration. So definitely that takes place, but it's important for parties that may, who have contractual relations that may be affected with sanctions, to be aware of this, because it also then affects the arbitral institution and the seat that you use. You know, there's statistics that show that Russia has now moved a lot of their contractual arbitration clauses to SIAC and DIAC because they don't face the same problems that they've faced in the more, you know, common arbitral institutions. So definitely very important. Pauline, just Sudhanshu touched on enforcement challenges that arise when sanction-related disputes are before an arbitral tribunal, and an eventual award is in relation to a sanction activity or against a sanctioned entity. Any comments there or thoughts there? Sorry, unmute, Pauline.
I was listening very keenly to him. He's been very, very elaborate. From what he's spoken about, it's just very, very clear that how we structure contracts in future will be very critical, that the language has to be very specific, and the language that would cover exemption from sanctions and maybe unilateral tariffs has to be very specific. That would mean commercial entities, governments have to take into account that future disasters are just not natural disasters, war, but sanctions. And with this prevailing geopolitical environment, the possibility of the unilateral tariffs, at the global tariffs such as that we've seen coming out from the US, or like national security tariffs that came out from the US that have even gone into arbitration at the WTO. If you look like the way that President Trump put in national security tariffs, and Biden, countries were going to the WTO to challenge them, especially the steel producing countries. So we are in a global environment that is very volatile, and the interpretation of force majeure is just not the traditional force majeure. And the tribunals, as you said, as you've seen, they are not open to openly interpreting these events into the force majeure clauses. So the restructuring of how we structure the arguments is going to be very, very critical, especially with countries like let me say, unions like the EU having even legislations that prevent their companies from relying on extraterritorial sanctions. So that's what that's really what's on top of my mind from the analysis of what's been happening, and from looking at the cases that are coming up. As you've seen recently, even a company has filed a Dubai, I don't know how you pronounce, FCIArb 2 has filed an international claim against Lebanon, what's happening in Lebanon, challenging measures that by the Lebanese Bank du Liban that have affected its investments. And the bank has defended itself. The prolonged political, economic, financial, social crisis facing Lebanon as a component factor to initiate a dispute. And the dispute is a recent filing. So we are going to see more disputes of such nature arising from the conflicts that are happening in the Middle East and also in the Russia-Ukraine situation. And how they spill to Africa, we don't know when and how they will spill to Africa. but it's something that the African legal fraternity has to keep a watch over. Because even within Africa, we have our own sanctioned countries and sanctioned individuals, sanctioned entities, and which also trade, who also have investments, and we will need to think through how to address such emerging issues that are coming up. Thank you.
Thanks, Pauline. Very correct. And I think two important points with enforcement is obviously the risk that if you try and enforce such an award in a jurisdiction under the New York Convention or the rest, it's likely that public policy arguments will be raised relating to sanction issues. So very important thing to consider based on where you're planning to enforce such an award. And then obviously the legislations in particular countries where enforcement is sought. I believe the EU and Switzerland have introduced legislation recently that prohibits the enforcement or satisfaction of any awards that arise from ISDS claim concerning Russia. So I think important to keep your eye out on that and be aware of it. So before I go to Pauline for the last question on this topic, Mrinal has been very patiently waiting. And Mrinal, I've chosen to keep you at the end because you really will give us context and sum everything up. There is a sanctions claim that we're dealing with in an arbitration scenario. What are the losses, or what are the mechanisms that really sanction claims can be quantified in terms of losses? Can you take us through that? I know, having worked with you in the past, that you have good experience dealing with sanction cases, including in Russia. So I think your input in that would be really good.
Sure. Thank you, Nikhil and FCIArb for inviting me for this webinar. And thank you, audience, for listening to us so patiently. I think Pauline and Sudhanshu both have touched upon several cases that we are currently dealing with sanctions, particularly the investment treaty arbitrations. And I would say the biggest loss that one can think of is a complete disruption of the business, a complete loss to the equity shareholder of the entire value of the company or the value of the investment. And that, of course, manifests itself in several forms and ways, depending on the severity of the sanctions that are imposed. But let me break down the impact of these sanctions into different types of losses or heads of claims and how it can impact the overall business. So first, and I would probably divide the impact into three broad categories. The first would be a direct economic and financial loss. Now, when I use the word direct, it's essentially directly disrupting the banking operations, right? Such as, there's an exclusion from the SWIFT payment system, or the assets are frozen, or you are limited access to the capital, right? Such kind of direct sanction, it's easier to quantify the impact. You would exactly know what's the loss that the company or the business is suffering, and you can easily quantify the impact on the cash flows, the existing cash flows and the future cash flows. There may be a certain sanctions that can hold the revenue streams or create financial volatility. The exchange rate disruptions can happen, and therefore the existing investments that the investors have made or the contracts that are existing can become economically completely unviable. Now, these are the direct losses that I'm talking about. And same with the tariff case. I'm not touching upon tariff because there the impact is very visible, very apparent. It's spoken about in public domain. Africa continent itself has suffered a loss of exports of up to 20% because of the tariffs that were imposed. So it's a very direct impact that one can see. The second one is more indirect and more subtle, because when your business starts getting disrupted on a day-to-day basis, it's ultimately the long run impact that you have to foresee. And in such situations, there could be sort of supply chain realignment cost that are involved. There could be logistical inefficiencies because you may, for example, you are forced to alter the logistics. You're forced to take a different route for the current Middle East scenario that everyone is facing. Several emerging markets have to think of alternate routes for importing oil, right? So there are logistical inefficiencies that are involved. There are higher costs that are involved. There are more compliance costs that are involved. So these operational disruptions, these supply chain disruptions, therefore, have to be assessed have to be assessed in a more complex way by doing various scenario analysis, by taking a more long-term view that how eventually such kind of sanctions is going to impact the business. Is a mitigation possible? How is that mitigation going to work out? Is that a reasonable way of mitigating your losses there? All these questions need to be assessed when you are calculating losses emanating out of any proposed sanctions. And then the third bucket, which is even more complex, is the overall macroeconomic impact, right? And when I say the overall macroeconomic impact, the first direct thing that you see is consumer prices, right? There's an increase in inflation. There's an increase in the prices of several products, not just consumer price index, but especially on imported goods. I was currently involved in an international arbitration where 60% of the raw materials were being imported. And because of a similar situation, of sanctions, the cost of the raw materials almost doubled. And when this cost almost doubled, it eats away your entire profit margin. Although the contracts that the company had with the ultimate customers allowed the company to pass on the higher cost to the customers, but there is only a reasonable extent to which you can pass on these costs. So eventually, the loss has to be absorbed by the company to a large extent, and not necessarily everything can be passed on to the customers. It's a call that the company management has to take. So when you have sanctions, when you've got increased tariffs, when you've got increase in inflation, you've got job losses, you've got a decline in the GDP growth rate, all of these will ultimately impact on the valuation of the business. Now, obviously, in such scenarios or in such disputes, you fall back on the same principle of valuation, which is but for less actual. The tricky part is the but for or the counterfactual scenario, because you'll have to then carry out the valuation, assuming there is no sanction, assuming that the world would have been absolutely fine. It would have continued without these tariffs or sanctions. So what is the value in that counterfactual scenario versus the actual scenario where you see the impact of those sanctions? And the trickier part is then you'll also have to project your cash flows in the actual scenario, because the impact of the sanction may continue for a short to medium term or even long term. So the impact of the sanctions is not just limited to a year, 2 years, depending on what is the economic impact, how long that's going to last. All of that eventually you'll have to consider in the cash flows before you can come up with a reasonable basis for the damages that are suffered. Thank you.
Thanks, Mrinal. Very enlightening. I think just to go to the final question, because we're running out of time on this topic on sanctions. Pauline, are you still with us? Pauline?
Yes, so I had to change the computer, so I'm having a challenge with one, but I'm here.
Not to worry, you can hear us?
Yes.
Okay, I just wanted to ask you, so having had that discussion on the effect of sanctions on trade and to states, what mechanisms or structures do you think trade agreements and investment treaties should be in place to preserve or to safeguard parties' interests?
Okay, first, as we've said, and then we've said, when it comes to contractual treaties, the force majeure should specify circumstances that may lead to force majeure, and countries and commercial entities must now, from now on, henceforth, specifically mention sanctions and unilateral tariffs as factors that could constitute force majeure. Failure to that, it will depend. It would be a limit. It could limit them in any disputes before arbitral tribunals and courts. Because particularly arbitral tribunals are tricky because they don't rely on precedents. So you'd be relying on the arbitrators that are deciding a case and how they interpret the law and how they interpret contractual provisions or treaty provisions. But courts could also be more consistent because if they have set a precedent that these issues could constitute a force majeure, maybe you could argue based on precedent. So to prevent such challenges, contractual clauses should be very specific in commercial contracts and government contracts. I hope some of my colleagues are online listening. Secondly, when it comes to tariffs, not only we've spoken about tariffs in terms of the global tariffs or the unilateral tariffs that we've seen emerging, but there are other tariffs that could arise within agreements, especially like in ESG matters like energy, where tariffs are increased by based on maybe the dollar rate, based on domestic factors. When in such issues, entities and governments should be ready to renegotiate their agreements. That would mean that contracts, commercial contracts, investment agreements should have renegotiation clauses, especially where you're dealing with like not really tariffs like what we've seen in the US tariffs, but energy tariffs or tariffs that are domestic that relate to domestic issues, mining tariffs, energy tariffs. Such issues are such that the contract should provide for proper renegotiation as a tool to prevent disputes. An interesting case that was settled in 2025, and I think it's worth my mentioning it, Barrick Mining Corporation versus Republic of Mali. This is a case that was settled by Mali government last year, where Mali had a mining code and it revised the mining code to increase state equity participation by up to 35%, raised royalty rates, and required immediate compliance. And that disrupted the company's existing mining conventions. And this is one of West Africa's largest gold complexes. When you read the case papers, it was not something enjoyable because this conflict between Mali Barrick Mining Corporation escalated to a point of employee detentions, where the government detained some employees, seized assets, military helicopters landing at the mine, seizing the gold, was seizure of the gold, and Barrick filed a case against Mali in January 2025. But the key issue was about resource, where Malian government wanted to get more from its resources. And so the parties had to come sit down and renegotiate. And there was a settlement, US dollars 430 million. But and the company has gone back into operations, having come to a settlement. But what you learn from this case is that renegotiation of circumstances, when circumstances change, like tariffs or maybe sanctions, can be a mechanism when relationships need to be preserved, especially when you're dealing with tariffs. And the need to, when African governments are seeking to take control of their resources, they need to structure treaties and agreements that would support proper sharing of proper allocation of benefits from these resources, rather than having to go that there need not be the conflict that we saw that happened in Mali in its challenging Barrick's ownership of share of the resources arising from the gold mines. So also African countries should also take into account, look into what the AFCFTA protocol on investment provides. It's instructive as if you use the AFCFTA protocol on investment, Pan-African Investment Code while drafting your treaties, to give yourself regulatory reforms, regulatory space leeway on policy issues, particularly that would affect sustainable development, environment, and governance issues. So there's need to try to balance the need to regulate and invest when it comes to investment. And as for sanctions, there's little to do except having force majeure clauses be very specific. Thank you. That's what comes on top of my
Thanks, Pauline. So, I mean, I agreed fully. To conclude, for private agreements, really, it depends on taking great care in the drafting of your contracts to ensure you have a specific way to raise a claim arising out of sanctions, which could be a force majeure clause, sanction clause, or as we discussed, the common principle of frustration, and really determining what is the proper seat for the arbitration and which arbitral institution is also very relevant. For investment treaties, definitely a number of African states need revision to the old generation BITs to, as Pauline said, ensure that there's regulatory compliance, but there's still room for sustainable development and the goals for each jurisdiction. So with that, and due to time, I'll just move quickly to the next topic, which is ESG disputes. But if any of the attendees have any questions, please do put it in the chat box, and we will ensure to leave some time at the end to get the panelists to respond to the same. So, Pauline, I'll come back to you. Just on ESG disputes, we've obviously seen a rise in environment, social, and governance obligations arising in private contracts. This has happened for a number of reasons. One is when a company based in Kenya is receiving, or in Africa is receiving funding from abroad, the overseas funders may have ESG obligations which they require the local entities to comply with. Obviously, there are regulatory compliance issues that parties need to follow. So what are the various ESG-related disputes that may arise in contractual agreements? And why is it becoming more relevant for African parties to pay more attention to these?
Well, I think we've been seeing various forms of ESG. I think ESG disputes began long way before the term ESG was formulated. I mean, for the Kenyan context. Kenya is known for the famous case, World Duty Free case, which was an early ESG dispute, which was decided that corruption contracts can be invalidated because of corruption. So increasingly, we are seeing environment, social, and governance objectives being incorporated into treaties and agreements, and even including financial reporting and accounting reports, audit reports, how companies are complying. But various ESG disputes have arisen, particularly I would speak about Kenya, where we saw one of the first ESG disputes related to governance, that is World Bank, the World Duty Free case. Sorry for the background noise. There's some construction happening, and where it was held that that corruption can invalidate a contract. The type of disputes Kenya, I will speak for Kenya, we've come across in international arbitrations. One was based out of a letter of support, a contractual dispute, such as mainly the Kinango Park arbitration, a project that stalled due to community protests. And these protests centered on the lack of proper community engagement and sensitization in the setting up of a wind park. And what was critical was the interpretation of a letter of support issued by government for the setting up of erection of the 38 wind turbines. And the investor said that Kenyan government stated force majeure, saying that Kenya government failed to eliminate a political event emanating from the protests. What happened? There were community protests. There was no community engagement. There was no community sensitization. And it was more like a divide and rule. Actually, I was in the field at that time. The farmers were very upset about how the manner of how this project was set up. And also, what we also noted is that they had also not gotten the relevant environmental impact assessments done to approve the project in that area. And owing to the protest, the investors said that it was a political event, but the tribunal, ICC tribunal, ruled that whatever happened was there was no political event, and the claim was dismissed, and the protests, the project went down and stalled, and it didn't take place because the environmental laws had not been followed. There was no community public participation, and public participation is a key tenet in setting up such projects. The kind of disputes we've also seen that are relevant for Africa, is we had a rare mineral case. Right now, Africa, there's a race for critical minerals. Kenya, I think, is one of the first countries that faced an arbitration in ICSI concerning critical minerals, the rare earth case in rare minerals in Rima, Kotek ICSI arbitration. And I was also in the team defending the case. And Rima is said to have rare earth minerals and some investor, and this was a BAT case, and some investor wanted to access the resources in Rima Hills. And there are shrines there, and shrines, so that means there was need to have community participation, get proper environmental approvals. It's also in a forest, and the community also protested, and the Kenya government was taken to court to ICSI, but ICSI declined jurisdiction. In terms of the tribunal, it started off with a preliminary objection by Kenya. We say that the mining license they got did not comply with local environmental laws, and that's what the tribunal upheld, and so the case was dismissed. And we are seeing globally ESG cases coming up, like in Colombia, where we have seen the Serge and coal mine dispute, Glencore International versus Colombia, where environmental and social impacts of operations of institutions. We've also seen some claims over in Argentina, where tribunals are dealing with human rights claims, a counterclaim on right to water, the UBESA versus Argentina, but still the tribunal found indirect expropriation. Interestingly, in this case, UBESA versus Argentina, the tribunal found indirect expropriation, but it held that human rights obligations on investors must be explicitly stated in a treaty. So this is very unique, and I found it very unique in the sense that this ruling, the UBESA versus Argentina, limits the effectiveness of ESG counterclaims. Because so that means the BAT treaties that we are coming up with have to start, the new generation have to really bring in the ESG considerations because of the limitation of the UBESA versus Argentina case. For the Kenyan cases, we had, I think we had good tribunals that looked at issues contextually, and Kenya was saved from having to pay huge sums of money to people who did not comply with environmental obligations. So you can see that the award for UBESA versus Argentina demonstrated that while tribunals may consider human rights instruments, direct obligations and investors are not automatically imposed. Explicit treaty language is required to bind private actors. So those are so we now need to think of how to draft BATs to clarify counterclaim provisions, especially where ESG requirements are. incorporating corporate responsibility in our treaties, and so that we can balance investor protection with state and with obligations to uphold human rights, environment, and other governance issues. Thank you.
Thanks, Pauline, and very rightly so. ESG claims have been there for a while, but we expect to see more of them as companies integrate ESG policies into their daily contractual relationships. And with regard to the treaties, I think we're going to be discussing the ICJ's advisory note later. Obviously, the ICJ advisory note that was issued has a direct implication on state responsibilities. And perhaps, Sudhanshu, if I can ask you to just give us some background on the ICJ's recent advisory notes on state obligations, the consequences of failures to abide by the state obligations. If I can kindly ask you, just limit it to 5 minutes or less, as we're running out of time. You're on mute, Sudhanshu.
Sorry, I hope you can hear me. Yeah, I'll be, I think, hopefully less than 5 minutes. I mean, obviously, the ICJ's advisory opinion is groundbreaking. I mean, and certainly is going to have a significant impact on investor-state dispute settlement and the investment treaty framework in general in the future. A lot has been written and said about it. I mean, Africa, was a very significant participant in the ICJ proceedings. I know 19 African states submitted written submissions in the advisory opinion proceeding. 16 African states provided oral submissions, and I think our law firm was proud to also represent Kenya, if I'm not wrong, in the advisory opinion proceedings, although I did not directly participate myself. But I'm aware of the significance of it. I think in terms of its impact, I will say that it's going to have an impact on 3 or 4 broad areas. Number one is its impact on the drafting of treaties. Now, most of us know here that the earlier generation bilateral investment treaties focused essentially on protecting foreign investors. Now, the newer generation agreements have taken a more balanced approach where they seek to accommodate state interests and incorporate non-economic considerations such as climate change. I think the ICJ's opinion is likely to accelerate this development. I know in terms of Africa, Pauline already addressed it. The the protocol, the AFCTA protocol already addresses climate change in Article 26 of the protocol, which requires states to promote and facilitate investments that support actions or mitigate greenhouse gas emissions. It also requires state parties to encourage investments that mitigate climate change impacts. I'm reading from Article 26 of the protocol. So I think more broadly, even though this protocol was adopted, I think before the ICJ advisory opinion, I think we are going to see a broad shift in how states negotiate investment treaties, and we are likely to see more adoption and integration of climate change provisions in new treaties. Now, second aspect of the ICJ's opinion would be in the implementation and interpretation of current treaties. Now, all I have to do is to refer you to the advisory opinion and the opinion of Judge Cleveland, who said in her separate declaration in this that and I quote her, the interpretation of investment instruments must be informed by states' obligations in respect of climate change under international law, including the stringent due diligence standard. This was a direct quote from the ICJ advisory opinion, the separate opinion of Judge Cleveland. So I think this is going to be widely cited and used in investment treaty cases existing and future in order to shape and influence the interpretation of commitments under investment treaties. For example, a core provision that is always invoked in bilateral investment disputes is the fair and equitable treatment provision. And one of the most essential protections that investors often invoke is legitimate expectations, which is to say, foreign investors would often say that they invested in a particular market with a certain investment-backed expectations in mind, and potential state measures interfered with those legitimate expectations and therefore constituted a breach of the fair and equitable treatment provision. So now, with this advisory opinion in mind, I think this puts all such investors at notice that states are likely to adopt more stringent and robust environmental regulations, and therefore they could not have had a legitimate expectation that such rules would not be followed. And I can give a practical example from a case, and that case is Rock Hopper versus Italy. This case was started in 2015 when Italy enacted legislation banning all oil and gas explorations within 12 miles of its coastline in order to prevent environmental harm to its marine ecosystem. Now, that measure effectively blocked this company called Rockhopper's project, and this company initiated a claim under the UK-Italy BIT and the Energy Charter Treaty, alleging that Italy's measure for banning offshore drilling in its coastline were inconsistent with its obligations under the treaty. Now, even though the arbitral tribunal ruled that Italy's refusal to grant a production concession constituted unlawful expropriation, if this case were to be brought today, then in light of the opinion, Italy would have stronger arguments for justifying the regulation as a defense to the expropriation claim. Another way it could practically impact, the ICJ opinion could practically impact investment treaties, and interpretation of them is on compensation. And as Mrinal has explained, I think in most investment treaty contexts, we rely on the traditional fair market value standard to assess the value of an investment. Now, in context of climate change, it would raise the obvious question: if the value of an asset is affected by climate change regulations and those regulations are foreseeable in light of the advisory opinion, does that mean that the value of the asset has declined as of the valuation date? That's a question that's going to come up and going to be addressed in future investment treaty cases. I think the other aspect of this is that it may give rise to counterclaims by states where investors undertake measures that impact the climate and lead to environmental harm. We've already seen some of the cases even before this advisory opinion, where states have sought to bring counterclaims against investors for environmental breaches of environmental laws. And I think that is only going to likely increase in the future. So I think, yeah, I mean, I'm going to leave it at that, but I think both in terms of state practice on drafting of investment treaties and ISDS, which is the interpretation and implementation of existing treaties, the ICJ's advisory opinion is likely to have a very significant impact.
Thank you, Sudhanshu. Definitely, I think the opinion will affect states in a number of ways and needs to be kept in mind when negotiations are on way for new generation BITs and similar obligations. You touched on an important point on quantification of losses in climate change regulations, given the advisory opinion. Perhaps, Mrinal, there's a good time for me to bring you in for your expert advice on that. So in your role as an expert, have you come across such claims where losses are arising out of breaches of environmental obligations or regulations that are currently in force, losses arising from new regulations relating to climate change? And if so, what are the mechanisms you use to quantify this loss?
Sure, Nikhil. So when it comes to ESG claims overall, I think again I would categorize them into four buckets based on my experience of dealing with them for the last few years. First is an environmental remediation claim which essentially refers to the costs that would be required to put the environment back to the required standard. So, from the perspective of the framework, this claim is straightforward because we're dealing here with the standard environmental damages, the pollution, the contamination, where the claimant would be seeking the cost recovery, and therefore, I mean, you see these kind of remediation claims a lot in oil and gas, mining, and industrial contexts. And from damages standpoint, the discussion usually centers on the scope of remediation, what level of cleanup is needed, is actually required, and whether the proposed costs to be incurred are reasonable, not reasonable, and whether all of those costs can be appropriately attributed to the alleged breaches. So there's an element of causation also there. There's also an element of timing, whether these costs will be incurred over a long period or not, which then leads into discounting and the present value calculations, right? And one perfect example on this is actually an India example. Sorry, I'm giving India example here, but there was on the coast of Kerala in last year, May 2025, and there's a Reuters article around that case. There was an oil spill that happened, and you will find such examples all across the world. And therefore, the state of Kerala has filed and is seeking a $1.1 billion claim on the basis of these environmental damages because of the oil spill. And there is a very large shipping company on the other side which is involved. It's a very interesting matter. I would request audience to go over that. The second head of claim are stranded assets, as we call it. Now, this is not about the past event. Stranded assets are more about the loss of future value. And the argument here is that because of the ESG driven changes or the climate driven changes, typically if there's a policy shift or a shift in the regulation, the asset can no longer operate as originally expected and therefore becomes uneconomic earlier than anticipated. Now, this is very commonly found in the carbon intensive sectors, and therefore the damages claim is then framed as a reduction in the value or loss of future cash flows. The biggest issue here again goes back to the principles of damages. How do you frame the counterfactual? What would have happened to the asset in the absence of the ESG related change or a policy change? And again, it gets complicated because of the causation issues, right? Because you have to separate the impact of the regulation from the broader market trends, economic factors, declining demand, technological changes, etc. The third one and the technical term that they call is the greenwashing, or in simple terms, is a misrepresentation claim. And that is very, very similar to your standard misrepresentation claims, where essentially the allegation is that the ESG related information or emissions or the sustainable practices or the governance standards, etc., they were misstated. And therefore, the investor or the claimant relied on that information while making an investment or acquisition. And therefore, the loss here is typically the difference between what was paid and what the asset was actually worth given the true position of the ESG. So pretty much like a post M&A, breach of warranties kind of position. And in fact, the latest version of the International Valuation Standards includes updates to explicitly guide valuation experts to consider ESG issues throughout the valuation process. And these updated IVS guidelines are available publicly and actually are quite useful on that front. And the fourth part is the general sort of the breach of ESG clauses. Now that becomes, and I think, Nikhil, you were referring to this earlier as well, that essentially now we see more commonly ESG obligations being introduced, being stipulated directly into the contracts, whether in supply agreements, joint ventures, financing documents, facility agreements. And these can be therefore framed as specific covenants or broader sort of compliance obligations. And when there's a breach here, then the claim would usually follow in terms of the standard contractual expectation damages like loss of profits, termination losses, or contractual penalties, right? So typical examples here would be sustainable sourcing clauses, emissions, performance warranties, ESG KPIs, and net zero aligned representations in M&A, procurement, long-term supply contracts. And therefore, the remedies that often look like the classic contract damages would be the cost to cure, the price adjustments, termination losses. Everything ESG specific, of course. So these are the sort of four broad categories where I would put these ESG related damages, claims, or losses. Of course, I'm not counting the overall human rights and social impact claims because they're difficult, they're more indirect, they're more subtle, but doesn't mean that they're not significant. It is difficult to quantify them, how they would translate into a financial loss, but they arise from issues like labor violations or community impact or failure to meet social obligations, right? So the immediate consequences there may be some regulatory actions, some project delays, some operational disruption, but from damages perspective, the biggest challenge lies: how do I link these events to quantifiable financial loss in terms of lost revenues or lost profits or increased costs, or in some cases, a reputational impact? That's it. Thank you.
Thank you, Mrinal. Very interesting. Clearly, all mechanisms we use in normal quantification of contractual breaches, but really here the issue is causation and the many variables that go into a climate dispute or a climate claim, and actually pinpointing what the cause of that was. Yeah, very interesting. Pauline, just for the final question, Pauline, if I can go to you. So how can East African arbitral institutions position themselves to hear disputes arising from these emerging areas, sanctions, tariffs, and ESG disputes?
I think first, the key issue is our institutions in East Africa. I'm speaking about NCIA or ESCJ or Kigali International Arbitration Center, because ESCJ also has the capacity to listen to arbitrations. First, I always say that first we need registrars and case managers who have a strong background in deciding this kind of disputes and ability to offer Secretariat services for these arbitrations. There is need also within not only the arbitration institution, but within the legal fraternity, need to work on our specialist expertise, having in our panels investment lawyers, not only commercial lawyers, contract lawyers, but also investment lawyers and international trade lawyers. Because as you notice, the disputes are increasingly becoming sophisticated, where the disputes are in intersection of different spheres of laws, maybe trade measures, environmental measures, international law measures, international law, commercial law, environmental law, all these complexities would come into one dispute. Roy was really updated us on what's happening within the LCIA, ICC, and ICC, the rules that are coming up to make for the European or the international arbitration institutions to adapt to these emerging issues. There is also need for our regional international arbitration institutions, NCIA, Kigali, ESCJ, to come up with also updated rules to be able to manage these disputes. For instance, rules, as you've seen, LCA have no sanction policies, compliance protocols, expedited measures to listen to adjudicate sanction-related cases, ESG cases. So there is also need for our arbitral institutions to look into their rules and policies to see how they could catch up with what's happening within the international arbitration systems, international arbitration institutions such as the ICC, LCIA, and the SIAC, as well as ancestors. So need to have new practice directions for sanctions, like emergency procedures to prevent asset dissipation within a sanctions freeze. For ESG we can see ancestral working groups have been working on third-party participation and allowing communities to file petitions for in cases of ESG, cases where communities are affected. So there is need for our institutions to update themselves and to update their rules so they can be able to have these cases being heard within the continent. And because the environment is changing, and these disputes will also catch up within the continent. And rather than having these cases moving abroad, it's better to have them heard within the continent, our own institutions, and grow up and grow our own institutional capacity to manage these disputes. And also having our panel lists updated to have arbitral lists of people with different expertise. Not only I know it's common to want someone who is a fellow of a Chartered Institute of Arbitrators, but we also need to look at subject-specific specialization within your panelists. If you have environmental lawyers, investment lawyers, international lawyers, trade lawyers, they would be able to, when they have the subject matter strength, they would be able to add value within these panels. Because now, as you can see, the most focus is training on module 1 of I'm a member, I'm an associate, I'm a fellow. But do you have the subject-specific expertise to handle this, complex arbitrations? And I remember when I was studying, our professors would focus more on the substantive knowledge rather than procedural knowledge, especially if you are to adjudicate this kind of disputes. The institutions to strengthen the arbitral procedures and the arbitrators to strengthen their subject specialist knowledge within this fields. Thank you.
Thank you, Pauline. All very relevant points. It's really about educating ourselves in these new areas, getting a specialization, institutions incorporating rules that aid resolution of these disputes. And I think obviously it'd be interesting to see how our judiciaries deal with similar situations with sanctions and all the cases we discussed early. That really would determine whether Kenya or any other African state would be considered a neutral or safe state when dealing with sanction disputes. Thank you, and that brings to conclusion, I think, due to time, the discussion for today. Can I ask any of the attendees to put any questions down in the chat if they have for the panelists? If not, we can, while we wait for any questions that the attendees may have, can I invite my panelists to give their closing remarks and just take this opportunity to thank them. I think it was very enlightening. I learned a lot from the panelists, so thank you. Sudhanshu, if I can start from you with 30-second closing remarks.
No, I mean, thank you for having me here. I think we are likely to see, especially in the ESG space, we are likely to see these issues come up more frequently in disputes because of the nature of our planet and the things that we are dealing with, unfortunately, in continents like Africa and Asia, even though African and Asian states are not responsible for the majority of the climate change that has occurred in the last 50 years. So I think we are likely to see a proliferation of that. I think the tariffs issue is probably temporary, and with the change in the politics here in the United States, we are likely to see less and less of a discussion. I think on sanctions, it's always been an issue and we've been dealing with it for a long time. I think we are likely to see arbitral institutions being more upfront and direct about dealing with sanctions in the future, because I think arbitration is a very unique and peaceful way of settling disputes. And I think there are ways in which we can help some of even these sanctioned entities to peacefully resolve their claims and disputes. And I think that has got to be reflected in how arbitral institutions operate. So I'll leave it at that. And I want to again thank FCIArb and the organizers for having me here.
Thank you. Thank you for your time. Appreciate your input, Sudhanshu. Mrinal, any closing remarks?
Sure, Nikhil. I just want to conclude on ESG that the common theme from a quantum perspective for this head is that EST issues rarely operate in isolation. So the main work for an expert when you all deal with quantum experts on EST is that you need to isolate the EST related impact, establish a credible counterfactual, and make sure that the loss being claimed is actually attributable to the breaches rather than to commercial or market factors. Thank you. Thanks, Nikhil, for inviting me.
Thank you, Mrinal, for taking the time. Pauline, any closing remarks?
First, I want to thank you for the opportunity. It's a long time since I was in a webinar. But the key issue is it's important now for me speaking is that it's important for the African governments, businesses to keep watch what's happening globally and prepare accordingly. Because there's going to be a ripple effect, especially with all this, the war that's happening within the Middle East and the war that's also happening in Europe. And since we are a small global village, it's important for us to prepare and mitigate from any legal costs or legal effects that would happen within the governments and within our institutions and within our businesses. So it's a timely webinar, and I thank you all, and it's nice engaging. Thank you.
Thank you, Pauline, for joining and for your contribution. So I don't think we have any questions. So clearly the panelists have done a very good job in addressing the questions that were posed to you. Let me take this opportunity to thank FCIArb for putting this together, all the organizers, the attendees, and obviously my panelists. Thank you all. And I should mention, if you have any questions or follow-ups or want references to cases, please reach out to FCIArb, and we'll definitely get that from the panelists for you. Thank you all, and have a good afternoon.
Thank you all. Bye.
Bye. Goodbye.
Bye-bye. Thank you.